following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the law surrounding leases and the recovery of property. What are remedies that are available for landowners in the realm of a breach of agreement, and how does the newly existing legislature contribute to the ease of this process? A very good evening, and thank you for taking the time to join us on yet another episode of Law, Land and Liberty, where we bring in key legal concepts and break it down for the layman. Now, today's topic is something that affects every one of us if in chance we are involved in the property sector at all, and that's on leases and the recovery of property that has been possessed and the specifics relating to the new legislature that we have seen come about just last year. The importance of this topic, of course, touches every single one of us, because lease is something that we're very much always completely in tandem with, specifically when it comes to immovable property as well. And there's a lot of specific intricacies that we have to get into relating to the complicated topic of leases, specifically on immovable property. Well, to speak about this, we have someone that is very well versed in this field, and that is Mr. Chamath, Fernando, attorney at law. So thank you very much for taking the time to speak to our audience here today in order to get better understandings on this recent special legislature that we have seen. Before we get into any of the specifics, here is a little bit of an introduction. Mr. Chamath Fernando is a civil practitioner, and he has been very well versed in this field, so we're in very good hands when it comes to the discussion of this very recent legislature and how it affects and further efficiency and increases the efficiency of the current legal process that we have in place relating to leases on immovable property. Before we get into the topic, here's a bit of a breakdown. First, we'll be talking about the fundamentals of leases and how it actually works in the general law. Next, we'll be talking about the special legislation that we have seen come about recently. And finally, we'll be talking about any reforms or changes to the law and how it has actually functioned in the practical context.
My name is Chamath and I'm a student of Sri Lanka Law College. My question is on fundamentals. What legislature governs leases on property?
All right, well, without any further ado, we have a lot to get into relating to this topic, not just about the new legislature that we have seen come about, but also the basics and the fundamentals. We have not really done much coverage on that before, and it's something that affects every one of us on an individual level. At some point in our lives, we've had to interact with leases. So before we get into any of the specifics relating to the most recent updates, I believe it's important for us to get a bit of a foundational understanding on how exactly leases work. So could you give us an overview into the procedure for giving a lease on an immovable property?
Yes, thank you very much, Anuradhi, and thank you very much for selecting this very important topic. I think it is a topic that will be very important for the general public. Now, when it comes to leasing of residential premises or even commercial premises, there are specific statutes that are in operation. First of all, I must draw a distinction between a formal lease and just a document sometimes these members of the public tend to sign. Now, a formal lease agreement has to be a notarially executed document. Now, the law that is in operation with regard to this is Section 2 of the Prevention of Frauds Ordinance, where it says the Section 2 of the Prevention of Frauds Ordinance has been amended recently in 2022, adding more features to secure the parties. Right? So, Section 2 of the Prevention of Frauds Ordinance says that a lease agreement or any document relating to immovable property has to be made in front of a notary and two witnesses, and the person who are signing the document has to be present at the same time, and they have to sign between each other. So this kind of a document, we call it a notarially executed document, and that document can be registered at the land registry in the relevant folio. So this sort of a document is the valid agreement or valid document that can derive rights and can give rights to parties. So this is the most important document when it comes to a relationship of this nature. So it has to be a notarially executed document.
Right. So the very basics is there is two means under which we have seen lease agreements per se actually happen. One is, of course, as per the execution of the law, we have seen notarial documents that have been certified and are genuine lease agreements. And you were mentioning, sir, another means. I think we have to get to that specifics later on in the program. But of course, now we'll talk about the fundamentals. Speaking on the fundamentals, sir, we've seen the creation of a lease agreement. Could you tell us a little bit about how exactly the process is, or what occurs when there is a breach of this agreement that you just mentioned to us?
Yes, as I said before, there can be a formal agreement made in terms of Section 2 of the Prevention of Frauds Ordinance, and there can be informal documents. So we, as you said before, now we are going to leave out the informal part. We will concentrate only on the formal lease agreement. So when it comes to a lease agreement, there can be issues. Now, as you know, in practical terms, sometimes the lessee, now there are two parties. First, we'll identify the parties. Lessee is the person who is getting the lease, and lessor is the owner of the property. So lessor gives this property on lease to another person who we identify as the lessee. So now, if you go through a normal lease agreement, a basic lease agreement, you can see there are certain conditions that the lessor has to fulfill. Then there are certain conditions the lessee has to fulfill, and there are general terms. So now if a breach happens, we'll say when the lease agreement comes to an end, lessee refuses to leave the property, right? Lessee refuses to hand over vacant possession of the property, or lessee fails to pay monthly or that lease rentals, or something like that, or he damages the property, something like that, or lessor, the owner of the property, disturbs the possession of the lessee. That there can be various problems that arise under a lease agreement. So when there is a situation like that, if there is a breach of the conditions, the lessor has the right to terminate the contract or the agreement. Or if the lessee refuses to leave the property, hand over vacant possession at the end of the lease period or at the termination, then lessor has to force that person to vacate the premises and hand over vacant possession. So in a situation like that, the general law applies, right? Firstly, we'll talk about the general law. General law applies, and general law says this is a civil dispute. So then we have to seek civil remedies, right? So we'll go into these remedies
exactly, sir. In relation to the remedies aspect as well, I believe, of course, you being in the civil practice, you would have seen this quite often, where when it comes to a breach of an agreement of lease, the first action that the parties would turn to is going to law enforcement authorities, to going to the police to file a complaint or anything of that nature. So could you tell us a little bit about what the role of law enforcement authorities is when it comes to the breach of a lease agreement? Yes.
As you said, now the very first thing a lessor would do to run to the police station, because he thinks actually his rights have been violated. So his first step would be to lodge a complaint. Now, as I said before, this sort of a issue is a civil dispute. So the police, the first point of contact will be police. The police station or police officers are not there to resolve civil disputes. They have certain powers, but mainly the police officers are there to investigate and report facts to the magistrate's court or a relevant court, and do the to handle criminal issues. These are property matters. These things have to be dealt with as a civil matter. So now the police, most of the time, when you lodge a police complaint, police will have an investigation or an inquiry and ask the other party also to come, and the police will try to draw a settlement. They will see whether there can be a settlement possible. And if the settlement is not possible, then the only thing police can do is to advise the parties to file a civil action in the relevant court and seek remedies in a civil dispute, in a civil matter. But police can advise both parties to maintain status quo or maintain the peace between parties.
So it's a peacekeeping aspect-centric role that the law enforcement can actually resort to. There are no specific powers handed over to them in relation to property disputes specifically. So I think that's important for us to understand as well, because despite lodging a complaint, that's not the end of the deal. We really have to go forwards in relation to property matters in order to resolve this problem. I think, sir, I interrupted you a few minutes earlier when we were speaking about the remedial aspects as well. And we were speaking about the general law, as you mentioned. Could you please explain to us, under the general law, what remedies actually exist for lessors when it comes to the breach of a lease agreement?
Yes, when we say general law, we are talking about pre-statute or pre-legislation era. Or now we have a special statute for this. Now, in 2023, it was introduced. But before that, what the general law was, that we have to file what we call normally in our day-to-day court activities, we call it a RE action. That's a rent and ejectment, but it's not actually not a rent and it's a ejectment action. So it's normally we call it a RE matter. We have to file a district court case. So the district court is the civil court, first instance civil court. The plaintiff will, in a situation like this, if the lessee is refusing to hand over vacant possession of the property to lessor, then the lessor will have to commence this action. So the lessor will become the plaintiff, right? He's the complainant. Plaintiff will have to file a plaint. That is the starting point of this action. Once the plaint is filed, notice, we call it summons, will be issued to the defendant. Then the defendant, as of a right, I'm emphasizing that part, as of a right, can file the answer, right? Then once the answer is filed, sometimes you find there are cross claims. Then if there's a cross claim, plaintiff can file a further document called replication. Then once the pleadings are completed, matter will be proceeded for pre-trial. And after pre-trial, it will be fixed for trial. Then trial can be a lengthy trial or a very brief trial. Normally it takes few years, right? With the workload we are having day to day, we can see that, right? So then after trial, normally there is a step called written submissions. That will be the final written submissions. Parties brief their arguments and present it to judge, and then the matter will be fixed for judgment. Once the judgment is delivered, whichever party who is dissatisfied with the judgment will have the opportunity of filing an appeal. Then the first step will go to the Civil Appellate High Court, and after Civil Appellate High Court there will be another step, that is the next appeal stage would be a direct appeal to the Supreme Court. So this whole process will take, normally, I'm just in practical sense, it will take more than 5 years, 4-5 years, right? So this, imagine owner of a property has to wait for 4-5 years to get remedy. It's not, when you look at it from a point of view of the owner, is not very friendly or not very advantageous to that person. So that there is a delay. That is not because of anyone's fault. That is because of the number of cases we have. There are other cases. District court has so many other cases, money recovery, divorce, so many other cases. So because of that, we can't do anything, but we have to work according to the time schedule that is available in the courts.
That's handed to us by the courts.
Yes.
I think a question of curiosity in relation to this entire process. You just explained to us what the process is that a lessor and also a lessee that has breached the agreement will have to undergo in relation to how to proceed with the court actions relating to this breach. This entire process that you mentioned, sir, is extremely lengthy, and as you mentioned, it takes at least 4 to 5 years. In your opinion, as a legal practitioner, do you believe that it is advantageous for under this specific legislature, not of course post-statute, but pre-statute, in filing cases even, because we see a lot of people saying, why head to the courts when we know that it's not going to give us justice anytime soon? What are your opinions on this, sir?
Yeah, it's like now, justice delayed, justice denied, right? So there is a problem that if the remedies are delayed, then the parties will be dissatisfied with the outcome. Whatever the outcome, they will feel that they have not been served with proper justice. So that is why the legislature had tried to give a kind of a solution to this problem by introducing a new statute. So that now the party need not to rely on the normal process. They can always file action under the new statute. But there are conditions. It's not, you can't just file a action under the new statute unless you have complied with the conditions that are set out in the statute. So that we will discuss those conditions separately.
Exactly. We have to get to the provisions as well now that we've discussed the introduction, the fundamentals of the previously existing legislature, pre-statute law, and also the inconveniences that come along with it that I'm sure a lot of us watching would have had individual personal experiences with, of course, not a fault to the court system, it's just how it has become in the present context. But before we go into the specifics relating to the special legislature that we have seen introduced, and how it, I suppose, revolutionizes the entire process of applying for justice in relation to this field. Let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Nilupul Ruinda and I am a law student. My question is on the new legislature. What are the key differences between the general law and the recent statute?
Welcome back to Law, Land and Liberty. We're in conversation with Mr. Chamath Fernando, attorney at law, and we were talking about leases and specifically the leases and the recovery of possession of leased properties or immovable properties. And we just spoke about the general law and the pre-statute law and what the context was relating to the hassle of actually applying for the legal process and obtaining justice in any way, shape or form. And conveniently, we did have to get into the specifics relating to the new special legislature. So once again, thank you for the previous segment. I believe we have a good understanding, and with that understanding, I think we should definitely go right into the current context, the new legislature. Could you please give us an overview how exactly the legislature came to be and what it is comprising of relating to the...
Yes, as I said before, this need was felt because of the lengthy procedure that we have to follow when we want to recover possession of a leased property. So this statute we are referring to Act number 1 of 2023, Recovery of Possession of Premises Given on Lease, Act number 1 of 2023. This statute came into operation on 17 January 2023. So now we have this new statute which has given a new procedure. Law is the same, but a new procedure. So under this statute, if I may read the long title, that will help our listeners to understand to have a proper understanding of the statute. This act is an act to provide for the procedure relating to the recovery of possession of premises given on lease under a lease agreement. That is very important. Lease agreement to regulate the recovery of arrears of lease rentals, service charges and liquidated damages, and to provide for matters connected therewith or incidental thereto. So you can see this act is a special statute that is focusing only on recovery of possession of lease premises, right? So firstly it says, now if I may give a kind of a broad introduction to this statute, it gives a special procedure where, as of a right, the defendant will not get an opportunity to file the answer. When I compared with the normal procedure, I said that once the plaintiff is presented to the court, summons will be issued to the defendant. Then defendant has a right to file his answer, right? So in this statute, that part has been removed, and defendant has to come to court and show cause why he should be able to, or why he should be allowed to present his defense. And if he fails to do that, then the court can give a judgment in favor of the plaintiff. So that procedure is very short. That is why this statute is special, and we will go into specific provisions as we proceed.
Exactly, sir. When it comes to specific provisions, I feel like, sir, before we get into that, I think it's important for us to understand, as you mentioned, the comparison between the previous legislature that was in place and the special legislature that we have seen come into effect last year. What are the key differences? How does it actually differ? What are the key changes that were introduced by this new legislation to this process?
Yes. Now, firstly, we'll first discuss about the institution of the action. Now, under the general law, you have to present a plaint, and then the summons will be issued, and the defendant can come to court and file his answer. And if there is a cross claim, plaintiff will get a further opportunity of filing the replication, and then matter will be proceeded for trial. Here, the plaintiff has to file an action by way of presenting a plaint, right? Presenting a plaint. Together with the plaint, the plaintiff has to present an affidavit, right? That will be the evidence, prima facie evidence to proceed for the court to give an order, right? At the very first instance. So the plaint, affidavit, then the lease agreement, and draft order nisi, and any other documents that are relevant, right? If there is a breach of lease agreement, and on that breach, if the lessor has terminated the agreement, then proof of that termination. All that has to be presented to court at the very first instance. Then the most important thing, now this is the most important thing, under this statute, a lessor will be getting the right, or lessor will have the right to file action only if there is a valid lease agreement. Now, at the beginning we said there are formal lease agreements, right, drawn in terms of section 2 of the Prevention of Frauds Ordinance, and there are informal lease agreements. Those are just documents. Sometimes both parties sign letters, right? Those are not covered under this statute. If a person has such a document, that person will not be able to get the benefit of this statute. So that is why I want to emphasize that fact, that when you are giving a property on lease, you need to have a notarially executed, registered lease agreement, right? Then you are entitled to come under this statute. Then, if there is an agreement, then you have to file action. As I said before, you have to present a plaint, affidavit, and relevant documents. Once that is presented, court will give a date to the plaintiff's lawyer to support his application, right? The plaintiff has to support his application. when you support, you have to show court that either lease agreement has come to an end and the lessee is still holding possession, or the lessor has terminated the lease agreement, but still the lessee has failed to hand over vacant possession. If the court is satisfied that there is a case, right, a satisfactory case in favor of the plaintiff, court will issue what you call an order, or rather decree nisi. Decree nisi, right? That is not a final judgment or a final order. It is an interim order, decree nisi. Then the decree nisi has to be served on the defendant, right? So once the decree nisi is served, defendant as of a right can't come and file his answer. He has to file a petition, an affidavit showing what his defense, and seek the permission of court to defend his case, right? So he can't file an answer.
It's not a right given outright.
Exactly, not a right. As of a right, he can't file the answer. First, he has to ask the permission of court. That is what we call leave to defend, appear and defend, right? Leave to appear and defend. So if he has a very good, very powerful defense, only court will grant him the permission to appear and defend.
And that might actually deter cases where we know there is no strong argument for it.
Yes, that will be the point where court will decide whether he has a good defense or not. If the court is satisfied that there is a good defense for the defendant, then the court will grant leave to appear and defend. If the court is not satisfied, then the decree nisi will be made absolute, right? And that will be the end of the case. So you can see now plaint, answer, replication, trial, judgment, appeals, right? All those have been now cut short by this special statute. Plaint and affidavit, then decree nisi in the first instance. Decree nisi will be served on the defendant, and the defendant is required to file petition and affidavit and ask for permission or leave from court to appear and defend. If the court is satisfied that there is a prima facie sustainable defense, then the court will grant leave. Otherwise, if the court is not satisfied, then the decree nisi will be made absolute. And that decree which was made absolute will be operative as a writ of execution. By that itself, the lessor, that's the owner of the property, can get the permission or can get the assistance of the court to get the lessee evicted from the premises.
Right, exactly. So that entire process completely shortens, but that also leaves a question for curiosity. Just to clarify, this means that the special legislature gives a bit of primacy to the lessor in relation to seeking justice, right?
Yes, that is correct. But at the same time, lessee is also given an opportunity to present his defense. If he has a genuine defense, of course the court will grant leave, and then he can file his answer and proceed as a normal case.
Right, exactly. Even if you're on the other side of this entire problem that you might be facing relating to lease, it's not that the legislature is designed or geared in a way that it would disadvantage either party. It's just that if there is an outright possibility, there could be some sort of exploration on that front.
Exactly.
I think, sir, now that we understood how the process, the basic process works in relation to the legal procedure, we could dive a little bit deeper into the specifics, into how exactly the rights of lessors and lessees have changed under this new legislature.
Yes. Now, the main thing is the time taken, right? Because as I said before, if you have to wait for several years to enforce your rights as a lessor, then that person, he will not get any benefit out of his own property, right? And the other thing is that the property, that his own property will not be properly maintained, and there will be a lot of issues. Then Thirdly, there will be breach of peace between the parties, right? So that is why this statute has given a very summary procedure to enforce your rights. At the same time, as a lessee, if you have a good defense, your rights will also protected under this statute, because you have given an opportunity to present your case and satisfy the judge or the court to give you relief if you think that you are entitled to whatever relief that you say you are entitled. So this is a statute, because this is not a new procedure. We can see a similar procedure under summary procedure in terms of our civil procedure code. This is a well established procedure, and given Debt Recovery Special Provisions Act number 2 of 1990 also has a somewhat similar procedure. Then under section 703 of the Civil Procedure Code, where liquidated damages, liquidated claims can be enforced in this way. So this is not a new procedure that has been introduced. This is a well established procedure which has been introduced with regard to this type of disputes. So that's why I say that this statute is a very positive one towards the elimination of delays in our judicial process.
Exactly. It helps to speed up the entire process and also just makes it completely much more efficient in order to deliver justice, specifically in relation to property. Of course, it's one of the most contested and the most complicated areas as well, and it's not something simple, it's property. I think specifically when it comes to, I think we mentioned it briefly beforehand as well, so you mentioned about a legally binding lease agreement that we have seen, and it's not just a letter that you sign. Just like that, sir, what are the other specific conditions that lessors must meet in relation to seeking justice from this special legislation?
Yes. Now, first thing, you need to have a valid lease agreement, as I said before. Secondly, now to evict the lessee, either you have to wait till the lease period is over, or if you think that the lessee is acting in violation of the agreement, then you have to properly terminate the lease agreement, because only upon that you will get the right to come under this or to institute action under this statute. So if you have not properly terminated the lease agreement, then you might find difficulties after you file in the action, because the lessee might come and say you have not terminated the lease agreement. The lease period is still going, or it's not over, and I am within the lease period, and the lessor has not properly terminated the lease agreement. So you have to first comply with those conditions before filing action under this statute.
Right, so that is something very important to look out for. You need to make sure you've done your part first as a lessor in order to seek justice from this statute, from this legislation. I think we have to speak about the specifics in relation to how the courts have reacted to this legislation and how it has played out in the current and practical context as well. But before we speak about any of those current developments and specifics, let's go in for a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
Hello, my name is Madanapal and I'm a student of Sri Lanka Law College. My question is on the future. How does this legislature change the landscape of recovering possession of leased property?
Welcome back to Law, Land and Liberty. We're in our final segment in discussion with Mr. Chamath Fernando, attorney at law. We were talking about lease and the breach of lease agreements and also the recovery of property by lessors. And we were talking about the new legislation, and we just actually touched on it very briefly. There's a lot of specifics in relation to it, but of course for the viewer to understand the very basics, the rights you are due under this new legislation, I think it's important for us to get to the most important question, I believe, when it comes to the practical application. As a practitioner yourself, sir, that you have seen this law in effect and you've seen certain numerous cases, what is the biggest piece of advice, or what advice would you give to landlords in order to ensure that they can seek justice under this new piece of legislature when it comes to recovering possessions?
Yes, firstly, I must say that this type of program is very important, because the general public will know that there is a new statute of this nature. The problem in our country is Parliament is passing so many statutes, but the general public is not getting enough information about those statutes. But there is a saying, or there is a rule, that not knowing law is not an excuse. You have to know your law. So these type of programs are very important for that. So first thing that the viewers should know, that there is a statute of this nature. If you have given on lease a property and if you need to recover possession, this statute can help you. That is the first thing. Secondly, you have to have a properly stamped, properly executed lease agreement. Because earlier I mentioned about decree nisi. Before issuing decree nisi, the court has to be satisfied with regard to these matters. If I may draw your attention to section 5 of the statute, it says, when the action is supported in court for the issuance of decree nisi in terms of section 4, if it appears to the court that the lease agreement produced is properly executed and the stamp fees are duly paid as required by law, and is not open to suspicion by reason of any alteration, erasure in the lease agreement, unless such alteration, erasure has been made before the signing by the executing parties, the contents of the affidavit filed is satisfactory to prove prima facie the case on the part of the plaintiff, then the court will issue decree nisi. So it is very important that you have a properly executed lease agreement. That is the first thing. Then, secondly, you have to, as I said before, you need to either wait till the end of the term of the lease agreement, or you have to properly terminate the lease agreement before filing action under this statute. Then, other thing is that you have to be mindful of the fact that this statute, that the lessee, right, will also have a defense. We don't know, considering the facts of the case, lessee will also come up with a defense. So if there is a possibility of that nature, you have to discuss that matter with your lawyer beforehand, not after filing the action. You have to reveal all material facts to the attorney that you are consulting, so that your lawyer will be prepared for that sort of a defense as well. So those are the main things I want to emphasize. And the most important thing is that everyone should know that there is a new statute, because this is just last year it has been passed, Act number 1 of 2023. So many, I think many viewers may not know about this statute. So that is why I say that it is very important you get to know about this. Anyone can read, even this is online, anyone can read this statute and go through it. If you have this, and the other thing is that even if you have a lease agreement which was executed before the operation of this act, before, as I said before, this act came into.
So it has retrospective power.
It has retrospective. So don't think that the agreements which have executed after this date will only cover under this act. Even if you have already filed an action, you can withdraw that action and file your action and a new action under this act. All those provisions are there. So if you have a dispute of that nature, it's best you consult a lawyer and get proper advice with regard to the new statute.
Exactly. I believe that's the most important takeaway from this program. If there's anything that our viewers could take away from the program, it's that this act has been coming into place and it's retrospective. It doesn't have to necessarily consider lease agreements that have been formed after the introduction of this act. And of course, you can withdraw actions and maybe file a new one in relation. And it could potentially have a shorter legal lifespan in relation to the already existing case as well. So you were mentioning about the fact that the other side of the other party or the lessees, maybe the individuals that were in breach of this agreement also have certain rights in relation to this new piece of legislature. Could you please give us a little bit of, before we go into how the courts have actually played a role in the practical implementation of this special legislature, are there legal remedies that are specifically outlined in this special legislature for lessees if they believe there's unfair eviction in any of those grounds?
Yes. Now, when it comes to lessee, if the lessee has been evicted or if there is a decree absolute made without giving proper notice to lessee, he has 1 year period to come before court and establish that, to say that I have not received the decree nisi. To put it in very simple terms, I didn't get notice of this action. Then he has 1 year period to come before court and say that I didn't get the notice of this action and allow me to participate. Then if the court is satisfied, court can allow that application. And if the lessee was unable to be present before the court when the decree nisi was issued due to an accident or some reason, a valid reason, then the lessee has the right to come before court and ask the court to give an opportunity for him to participate in this action. And the lessee now, lessee has or lessee or both parties, it's given to both parties, has a opportunity or has the right to appeal against a final judgment as well, or that is order, decree absolute. So there are a lot of remedies, or there are a lot of provisions that have been introduced by this new statute to safeguard the rights of both parties.
Exactly. So it's not, I think that's very important since we are closing in, unfortunately, on the duration for this program. Very unfortunately, it's a very important takeaway that it's not just the lessor that's being protected under this law. The adequately deserved rights for the lessees as well are in existence. It's not a one-sided piece of legislature, and there is justice that can be sought from both parties in relation to the breach of agreement, lease agreements when it comes to immovable property and its recovery. So unfortunately, we have come to time in this discussion. There is a lot more specifics to discuss as well. We couldn't exactly touch on the court implementation aspect, but considering that the law is fairly new, we're still seeing any sort of emerging judgments that are currently occurring. Thank you very much, sir, for taking the time to give our viewers a very basic and important insight into this new piece of legislature and to educating us. Thank you very much.
Thank you very much for inviting me.
All right, well, property recovery and the ownership of property in itself is something that affects every homeowner, and it is essential that we stay well informed on how the law seeks to protect our right to justice in this field. We leave you tonight with the words of American journalist Margaret Mitchell. The land is the only thing in the world worth working for, worth fighting for, worth dying for, because it is the only thing that lasts. That's all we have for you tonight on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube page, youtube.com/otherderana English. Thank you very much for watching. Have a good night.